State of Florida.
May it please the Court. My name is Valerie Lennon, and I represent the appellant, Stephen Bible. At this time, may I reserve 5 minutes for rebuttal?
Yes, ma'am.
There are two issues before the Court today. First, whether or not the circumstantial evidence of intent was sufficient to survive the motion for judgment of acquittal. And second, whether the trial court committed harmful, reversible error by allowing the state to argue during closing arguments evidence that was, or inferences that were not supported by the record. Unless the Court has issues regarding or has questions regarding that second issue, appellant would like to stand on his brief and utilize the Court's time to discuss that first issue. And turning to that first issue, the trial court erred by denying the motion for judgment of acquittal because the circumstantial evidence of intent was not inconsistent with Mr. Bible's reasonable hypothesis of innocence that he was attempting to claim these properties through adverse possession rather than organized scheme to defraud.
What steps did he take under the statute? What correct steps did he take to establish a right to this property by adverse possession?
Well, under the statute, for starters, Mr. Bible took possession of the property. He had only possessed the property for 45 days when he was arrested. He filed a notice in the public records, not required by the statute, but it did give public notice. He sent letters to each homeowner.
He filed a notice with the clerk of court, right?
Yes, Your Honor.
And that filed with the property appraiser as the statute requires.
But he still had another 10 months to file that notice. He had.
Back to the original question, what legal steps did he take other than saying, I now own this property?
He sent notices to the homeowner, sent letters to each homeowner, and he did show those to law enforcement.
Did any of the homeowners indicate that they received anything from him?
Several of the law enforcement, or at least one of the homeowners testified that they never received it.
Did anyone say they did receive anything?
I don't believe they testified to that, Your Honor.
Can I interrupt? One of the things, I guess I want to be able to focus on that very first thing. You've indicated that he took possession. The statute doesn't only require possession. Doesn't the statute say, and before we get into the other requirements, and I have the statute right in front of me, when the possessor has been in actual continued possession, that's what you're making the claim, for 7 years, and here's the qualifying, under a claim of title exclusive of any other right. So tell me what evidence that was presented in terms of his reasonable hypothesis of innocence regarding what claim of title was he asserting?
Exclusive of any other right. He was asserting an adverse possessory interest, which he did have 7 years to perfect, by taking possession of the homes, and he testified that he cleaned these homes up, that he cut the grass, he got them ready to rent, and then he asserted renters in each home to solidify his possessory interest in each home, exclusive of anyone else. So the tenants exclusively occupied the homes to the exclusion of anyone else.
But doesn't he have to have a claim of title? And this is what I'm trying to focus on. What is his claim of title?
His claim of title, if I understand your question correctly, the claim of title is that the properties were abandoned. So he.
Well, let's focus on that a minute. Were they truly abandoned? Wasn't there testimony presented that one of the owners happened to be a deputy sheriff from Pasco, and he testified that he owned this property, he was in the process of selling it, and then he scheduled an inspection, and lo and behold, he goes to his home, the locks have been changed, and then there's a sign saying, call the defendant. He calls the defendant comes in and says, this is my property. I mean, that for me doesn't sit well.
The property was vacant, and he didn't testify that this was my home, that I lived in it, or anybody else was living in it. The property was vacant. The locksmiths, both of them testified that they went out to each of these homes and they were vacant.
Well, let's talk about the locksmith. Didn't the locksmith testify that he spoke with the defendant told him that he acquired all these properties by auction? That wasn't accurate, was it?
That was hearsay testimony, and that's his version, his recollection of it.
But if you're talking about a reasonable hypothesis of innocence, is it really reasonable when you start, like Judge Black said, you know, he didn't follow the statute, and the statute is very clear, shall, didn't pay the taxes. I know his argument was they're not due, but then let's take it one step further. he could not have even paid the taxes on this, even if he was even after a year, because he's not the title owner.
Had he filed the actual notice, he could have.
But he didn't.
But he had another 10 months to do so. I mean, let's look at this in perspective. He was arrested 45 days after taking possession.
Let's suppose somebody is found in a house late at night and the people, or the sheriff's department arrests him and charges him with burglary, and the defense is, well, I was just in there exercising my right to adverse possession. Is that a valid defense? Will that work?
It is, because if we allow someone to be arrested for burglary, trespass, any degree of larceny, when they're attempting to claim a property through adverse possession, then we have a real conflict between the civil law and the criminal law. So if we look at it under the common law, abandonment is a complete defense to larceny,
So any
trespass,
burglar
burglary.
now can claim that they're not guilty because they were exercising their right to adverse possession?
Yes, Your Honor, and there's a civil remedy available to that property owner of record. It's an
So that's
ejectment
not a
action.
crime. If I, quote, abandon my property by going up north for 3 months in the summer and you move in, that's fine. I'm left to a civil remedy. As long as you just say, well, look, I claim this house by adverse possession. It's not his house, it's mine. I claim it.
No, Your Honor, I go up north for 3 months in the summer too. I have somebody cutting the grass. I have somebody to come by and check on it. It's not like in these cases where these cases were abandoned and these homeowners testified. The house went into foreclosure, except for the deputy.
Well, the deputy. Let's not forget about the deputy.
But the house was vacant. There was a civil remedy available to him of ejectment, not necessarily.
Let's go back and talk about his intent for a minute, because I think that was basically your defense, or the client's defense in the trial court. He's arguing that because he thought what he was doing was legal and he was validly exercising his right to adverse possession, he couldn't be prosecuted under this organized scheme to defraud because his intent was pure. But if ignorance of the law is not an excuse, isn't it sufficient to prove the offense that he had the intent to do exactly what he did, which was to go into these places and collect rent that he wasn't really entitled to?
But it's not ignorance of the law, for starters. Going back to intent, when law enforcement showed up to question him about what he was doing, he showed them the leases. He showed them the notices. He said, this is what I'm doing. I'm attempting to claim them through adverse possession. It's not ignorance of the law because Section 95.18 said you can claim properties through adverse possession this way.
It's a brilliant defense, quite frankly. I mean, rather brazen. I mean, when you think about it, that is, at least as when I read this, I'm like, what a clever way. He had an answer to everything. He didn't file it with the property appraiser's office, and he said, oops, I filed it with the clerk of the court. Come on, the statute says property appraiser. Why was that required? Because the property appraiser would have notified all the owners of the property, so he had an excuse as to that. Oh, and I'm doing it all open and obvious. Again, perfect excuse, which the jury did not buy it. And so, with his intent, he's trying to claim, well, I'm all innocent because I did everything open and obvious. Well, if I decide to walk in to a convenience store, very open, I'm going and I decide I'm going to shoplift that. No, I was intending to pay it. I'm doing it very open. That, for me, doesn't really excuse what he did.
In respect to the jury, they did not get a jury instruction on adverse possession. I don't know why that didn't happen, but they were expressly told by the state during closing argument, it's not your job to decide whether he's taken these properties through adverse.
The statute.
He did read the statute, Your Honor, but there was no specific jury instruction for them. But the state specifically told the jury, it's not your job to figure out whether he's taken these through adverse possessions. Did he intend to defraud these homeowners?
Well, let me ask you this. In the Ohio case, State versus Burrell, they affirmed a conviction under similar circumstances for theft by deception, which seems to be relatively similar to what we had here. Why shouldn't we follow State versus Burrell and affirm?
The defendant in Burrell did not claim he was trying to take the properties through adverse possession. And there was some, let me just double check my notes here, he did attempt to conceal his actions to law enforcement. When they showed up and asked him questions, number one, he didn't say, I'm trying to take them through adverse possession. And then when law enforcement questioned him, he said that the owner of record gave him permission to rent the houses. Couldn't pick her out of a lineup. Later he admitted that wasn't true. So as the case law here in Florida says, if there's no subsequent attempt to conceal the actions, then that negates any inference of felonious intent, and that's from, I believe, the Maddox case. Also, of the other cases that the court sent out, in the Brown case, that case was a very limited, the only issues were whether or not the charging document was required to negate the defense of adverse possession.
Well, Brown actually helps you, doesn't it?
It does. It says that...
Because it said that if the person in possession is entitled to the rents as against the title owner.
Actually, I believe that was Lepeshky that said that.
That's a California, the California one did that. Yeah.
In dicta, because this was kind of going beyond the two issues before the court, the law review article that they cited characterizes adverse possession as efficient theft. But if you characterize it as theft, then again you have a civil statute that's in conflict with a criminal statute. What they actually held was that even if adverse possession was an exception to burglary, which we don't, it wouldn't be available to the defendant. So then it goes back to under the common law, if the property's been abandoned, then essentially that property owner relinquishes any right to claim burglary, trespass, larceny, anything like that. So looking at Lepeshky, which is also along the lines of Allred from Utah and the Iowa case as well, what the California court said was that the possession requirement can be satisfied by putting tenants into the property. And it's because someone who adversely possesses the house or attempts to adversely possess a home values that property more than the owner that's abandoned it. So, we saw this in the foreclosure crisis. We all had a house in the neighborhood where the weeds were grown up, the roof was falling in, no one was taking care of it. In turn, all of our property values around it went down. The city's property tax revenues went down as well. When someone steps into that house, cuts the grass, cleans it up, takes care of it, then all of our property values go up, the city's tax revenues go up as well. That's the real...
What if there were 10 other Mr. Bibles and they all went out and tried to take possession of the same properties? Aren't you inviting some kind of open warfare where people will try to get control of these properties so that they can claim the rents and acquire title by adverse possession?
Your Honor, that's nothing that a civil court can't handle through an ejectment action. It's not an open warfare. We don't have that here, but it's something that a civil court can handle through ejectment action. Traditionally, that's how adverse possession claims have been dealt with, through ejectment actions, not through criminal proceedings.
How many properties did he do that? Was it 29 properties?
The state only presented evidence of, let me look at my appendix here because I had that written out.
I think they presented 10, but I read in the record that there were a total of 31 that he rented out to people.
Which is what the state claimed, and again, they only presented evidence of 10.
And when he collected the rent money, it was kind of interesting. What was his response when he was asked the question, why did you not return the rent money to the renters?
It wouldn't be hostile possession. And after he'd been arrested. So if he takes rent money before he's been arrested and he gives it to the owners, well, that's not hostile possession. That's not adverse. After he'd been arrested, why didn't I return the money? Well, that would be witness tampering.
And he never, it was interesting, the mortgage holders on this, he never contacted them or tried in any way to reach out to them, correct?
He did testify that he tried to call them, and there was quite a bit of discussion. That kind of goes into the second issue as well. But whether or not the mortgage company would speak to him has no bearing on his possessory interest in the property.
Because he pretty much testified, well, they wouldn't talk to him because he's not the owner. He doesn't, hold title to the property.
Correct. Well, no. Well, that's not correct. That was the testimony, but that's not a correct legal inference. That's what the state argued going into the second issue. There are plenty of times where, just as an example, a husband and wife are on the deed to the property, but only the wife is on the mortgage and only the wife is on the note. Either she had better credit or she was able to get first-time homeowner financing. The mortgage company will only speak to the person on the promissory note. So just because she's on the promissory note doesn't mean she's the exclusive owner of the property. Her husband has an interest in that as well, or another family member.
You said that, I thought I understood you to say that he sent letters to the owners. Is that correct?
He did. He testified to that.
Are those letters in our record or no?
They are not. When he showed those letters to the detective, obviously that evidence was seized. It did not come into trial.
So we don't know what the letters said, actually.
No, Your Honor. And the leases, for that matter, as well, didn't come into evidence either.
And no owner testified that they ever received such a letter. So as far
Correct.
as we have no record before us that such a letter was ever sent, other than him saying that he sent letters.
And I believe what he said was he sent it to the address on record with the property appraiser. Am I quoting that wrong?
So why isn't the jury free to reject the defense that this was just a good faith effort on his part to do what the law allows?
He said he sent them. They didn't. All they said was.
I mean, why? So the jury's faced with a decision. Either this is a scheme to defraud, and by the way, Mr. Bible had talked to lawyers about this, right? Why aren't they free to believe, you know what, he knew exactly what he was doing. This is his scheme to gain ownership of homes that he didn't pay for. And his explanation is unreasonable. Why shouldn't we affirm on that basis, which seems very rational to me?
Because Mr. Bible testified that he did everything the state.
Well, he testified to that, but obviously the jury didn't buy it.
Because they did, if I could just step back for a minute. He testified he did everything the state said he did, except for intending to steal it. So even though he said he sent those letters, all they said was we didn't receive it.
It has to be reasonable.
It is reasonable. The state of Florida says you can do it.
No letters put before the jury that he tried to notify anybody. What the jury knew is that he filed notices with the clerk rather than the property appraiser. Therefore, notices weren't sent that otherwise would have been. And it looks a whole lot like it's either he's pure of heart, pure of motive, or it's a scheme to defraud.
Your Honor, this all happened after 45 days. So he said he sent letters within that 45 days. They said they didn't receive them. There's no requirement in the statute that he immediately notify those homeowners that he's taking possession of their property. Only that the 7 years starts to toll as soon as they're on notice. So it doesn't say immediately you have to notify them, but you have 7 years once they get actual notice, once they know you're in their property, to perfect your claim.
All right. Ms. Lyman, we've asked you a lot of questions. I'll let you go over. So you're past your 15 minutes if you want to save any time for rebuttal.
Thank you, Your Honor.
All right.
May it please the Court, Timothy Freeland here on behalf of the State of Florida. The defendant here is charged with scheming to defraud, and the requirements for scheming to defraud, what the state had to establish was that the defendant entered into a systematic course of conduct with intent to obtain property from one or more persons by false or fraudulent pretenses or representations. I don't believe that there is a dispute as to the first two. He did engage in a systematic course of conduct. He was trying to obtain by adverse possession, as he claimed. I believe the record shows with more than 70 homes that he did this with. He only attempted to rent out approximately 31. There isn't any intent that he was trying to, there isn't any argument that he was trying to obtain property from other people, somebody else's homes. The real dispute comes down to, was he doing this with the intent to commit false, fraudulent pretenses or misrepresentations?
Let me ask you about that, because the
Yes,
statute, he wasn't charged with theft,
No.
like the Ohio case. He was charged with a scheme to defraud, using fraud or false pretenses.
Right.
And fraud and false pretenses generally involve some kind of a false representation that's made with intent to mislead. And in the trial court, the state's theory was that not that he had misled the tenants, but rather he had misled the owners and the mortgagees, because there was a statement of particulars filed to that effect. So where are the false representations here made to the owners and mortgagees? I just don't see that, and counsel's told us that the the so-called letters to the owners didn't come into evidence, so we can't rely on that. And it doesn't appear that he even talked to any of these people. So how is this a scheme to defraud?
He did speak to one of the property owners. That was Deputy Bizzetto, and we find that on page 315 of the record. When Deputy Bizzetto noticed that the locks had been changed on his house, there was the defendant's phone number in the window, and so he called up the defendant, and the defendant told him, "It's my property, you stay off." And that, for a little while, deceived that homeowner. He testified that he thought that maybe he actually had purchased it because the house had gone into foreclosure, maybe there'd been a sale, and so he was deceived by the defendant's statement to him. The defendant had never purchased the home, never had any possessory interest in it, and had no right to claim to the real owner, "You don't own it anymore, stay off." The majority of the misrepresentations here were with regard to the renters of the property.
Yeah, but that wasn't the theory at trial.
I think the theory of trial evolved as the case proceeded. Evidence of misrepresentation at the trial really focused on what the defendant said to the renters at the time that he was renting the properties out.
Yeah, well, that certainly wasn't what was in the statement of particulars that the state filed.
That's possible. If that's so, then the evidence of misrepresentation would be limited to what the defendant actually said to the homeowners. And there was not very much evidence in the record of that. The defendant testified, he agreed that he did not own these properties. He testified that he rented the properties out without the right to rent the properties out. Really, the evidence of adverse possession in this case is really just a red herring, because the defendant did not do anything other than take possession of the property to establish his claim of adverse possession. As I argued in the brief, he was required to file notice with the property appraiser's office, and he did not do that. He was required to take possession, he did that. As far as following the actual legal requirements, that he did not. With regard to the misrepresentation, there is plenty of evidence of misrepresentation as to what the defendant told the renters. Every renter that testified stated that the defendant told or led them to believe that he had the right to rent out these properties. Brian Cazzera testified the defendant rented him the house and told him that he was a property owner, property manager of that house. Kai Wisdom rented the property from him. The defendant admitted on cross that he did not own the house. Sharon Shepard testified that the defendant told her that he was the property manager. And defendant admitted on cross that he didn't own the property. Julie Crosby, another renter. The defendant led her to believe that he was the owner of the property and had the right to rent the property to her. Patricia Hawkins, same thing.
Wouldn't all of those constitute fraudulent pretenses even without face-to-face or written interaction with the actual owner?
They would.
I mean, if his ultimate goal was to obtain ownership of these properties by adverse possession, then it seems to me the rent is just a means to an end. It's just a scam. Well, he's happy to collect the checks, but what he really wants, according to him, is ownership.
That's what he said.
And just reading the statute, it seems to me you can accomplish that without talking to the owner.
Without talking directly to the owner.
Directly.
I think, of course, the statute does require that he notify the property appraiser, and the effect of that would be to provide notice to the owner. The defendant's attempt to contact the owner is really just surplusage. His direct attempt to contact him. Under the statute, he didn't have to do that. So the court is certainly right about that.
And Judge Walsh, I think, asked that question. I have not seen no letters at all presented in the court below.
That's correct. They were not. They were not presented. So the only evidence we have of the defendant's claim that he tried to contact the owners was his own testimony. There wasn't anything else presented below that I'm aware of, that I've seen.
What do you make of the California case, which suggests that the person in possession is entitled to the rents regardless?
The California case is distinguishable from our circumstance because if we look at Head Note 1, the California case it cites to their own statute, and they have a different statutory scheme than we do. And as we look through these cases, most states have different statutory requirements for obtaining property by adverse possession. Some require 5 years, some require 10 years, we require 7. In this case, their statute actually confers on someone who is trying to obtain property by adverse possession, actually conveys to the adverse possessor a modicum of possessory rights.
Because it says, look at the statute, occupancy for any period confers a title.
Correct. So if I were to go on vacation and someone moved into my house in California or decided to rent it out, apparently they could do that if they were seeking adverse possession. Now, it's supreme to anybody except for the state or whoever actually owns the property. So under this statute in California, he could not be charged with grand theft because under their statutory scheme, which is obviously very different from ours, he did have a possessory interest in the property. And that kind of fits in with the law of adverse possession because adverse possession is designed to prevent lands from going fallow. If there's land out there that's vacant and nobody's using it, I can claim it by adverse possession, and eventually we put it back into use. But adverse possession is entirely consistent with someone being charged with trespass. You actually have to be adverse to the real property owner. In Florida, if I note somebody is adversely possessing my property, all I have to do is say, stop that. And that's sufficient to interfere with their adverse possession. It has to be truly adverse. The California case, therefore, doesn't really help the defendant because their statutory scheme is different from Florida's.
What should we conclude from the fact that when the legislature amended the adverse possession statute in 2013, apparently to address this problem, they didn't say that this kind of conduct constitutes use of an organized scheme to defraud. It just constitutes basic old-fashioned theft.
Well, that's apparently the way they want it to be now. That doesn't mean that that's not the way it was back then. We're traveling under the statute which was in effect at the time. The legislature didn't really address whether this is going to be prosecutable under one offense or another offense. If the defendant were arrested under the new statute, we would pursue a different course, but he wasn't. We're traveling under the previous statute.
How do you address counsel's argument that if someone is in a place and charged with burglary, they can defend based on claim of adverse possession?
I think they could raise that claim. I don't think it would fly. You're welcome to advance any claim that you have any basis for. Obviously, I think someone claiming adverse possession through a burglary would have had to plan it out quite far in advance to the point of filing a notice with the property appraiser's office and following any of the other schema that our statute requires. I think the defendant is free to try to advance that defense, but I don't think it flies any more than this one did. I don't have any other argument.
All right. Thank you, sir. Ms. Lennon, we used up a lot of your time with questions, so I'll go ahead and give you your full 5 minutes for rebuttal.
Thank you, Your Honor. I'll be brief. As to the question from Judge Black about defrauding the tenants, there was no requirement under any rent skimming statute or any statute in Florida for Mr. Bible to disclose his possessory interest in the property to the tenant or any.
No, I wasn't referring to defrauding of the tenant. I was looking at the scheme to defraud statute 817.034 4D, and it defines a scheme to defraud as a systematic ongoing course of conduct with intent to defraud one or more persons or with intent to obtain property from one or more persons by false or fraudulent pretenses. His ultimate goal here was to obtain title by adverse possession. And my point was not that he was misleading or deceiving the tenants, although I think he was. My point was that you can accomplish what this statute forbids without direct interaction with the homeowner, because the fraudulent pretense was what he was presenting to the tenant in order to set up the claim of adverse possession.
Not really, Your Honor, because there is no requirement that
He was saying to people, in effect, I've got the right, I've got enough interest that I can rent you this property, okay? If I left my house and let the weeds grow up for a month or two, Mr. Bible could rent that property out. He could rent my house to somebody. They could move into my house, and that would be fine.
until you filed a civil ejectment to kick him and the tenants out.
According to you.
Not a crime, it's a civil remedy. This is a case of remedies. This was a civil remedy. For foreclosure, for that matter. My house is in foreclosure, it's in bankruptcy, I've declared it in a bankruptcy state. Meanwhile, the title still shows as you being the owner of record. There's no requirement to disclose that to the tenants. If I remember correctly, and I'd like to be able to file a supplement with this with the court, I believe Detective Sudu testified that Mr. Bible showed him those notices. I could be wrong, I don't have that with me, that testimony with me.
No, I think he testified that there was a notice on his house.
And I believe he
the
testified that
window.
Mr. Bible showed him his files, and in those files were the letters. I'd like to double check that for the court. As for the statute change, when Mr. Bible was doing this in 2010, there was no statute, there was no case law in Florida that said this was illegal, that this was theft or burglary or trespass. Nothing to that effect. There is now. But in the meantime, California, Utah, Iowa, other states have said this is okay. There was nothing in Florida to put Mr. Bible on notice that his conduct might be criminal. And if there are no further questions from the court, thank you.
All right.